Okay, I see we have some participants coming on.
Mm-hmm.
I'm just going to wait a moment for a few more before we get started. It's not 9 o'clock yet, so we'll just hang on. I wish I had some music in the background here for everyone, but I don't.
Matt can sing if you want.
That's right.
You don't want to
Karen
hear
can be
that.
the backup.
Yeah, you don't want to hear that.
It can't be any worse than us. So you're just coming back from a cruise ship. We were doing we were with my nieces and nephews, and we were doing what is it, karaoke. That was quite funny. A lot of bad singers. Okay, I'm just going to give it just a moment more before we get started here, just to see that everyone's on. I think there's just a couple more people are about to attend. All right, I think we'll get started now, everyone. So good morning, everyone. I'm Jeff Greenfeld, and I'm from Greenfeld Financial Management here in Ladner. I want to thank you all for attending our webinar called Estates Gone Wrong, which is all about the importance of comprehensive estate planning. My guests today are Matt Gottlieb, he's the key account manager, and Sarah Hillier, Senior Director, Trust Solutions from Clear Estates. Now here at Greenfeld Financial, what we've done, we've partnered with the knowledgeable estate professionals at Clear Estates to help our clients with their straightforward, transparent estate planning, the settlement solutions using state-of-the-art technology, as opposed to what was in the traditional ways of doing it in the past. Now, as the key account manager for Clear Estate, Matt's our first point of contact, and he's he would be able to assist our clients in setting up their estate planning needs. So, but before we get started today, I want to let everyone know who's attending that they'll all be muted for the duration of the presentation. If you've got any comments or questions, we ask that you enter them into the Q&A or the chat box that you see on your screen there, and we'll be able to answer them during our 15-minute Q&A session at the end of the webinar. And lastly, of course, this webinar is being recorded, and the link to this recording will be emailed to everyone who's registered. Now, I want to hand over the webinar over to Matt so he can introduce Clear Estates and our guest speaker, Sarah, today. So over to you, Matt.
Yeah, sure. Hi, everyone. Thanks for that, Jeff. Pleasure to be with you all today. As Jeff mentioned, my name is Matt. I am a key account manager here at Clear Estate. I've been here for just about 2 years now, and my role is to help families understand how Clear Estate can support them through either estate settlement or estate planning. I have a financial background, but I jumped at the opportunity to join Clear Estate and support its mission. I lost my mother suddenly about 7 years ago, so I really understand how important it is to properly plan for your estate, to make it as easy and simple for your families as possible during a very tough time. Clear Estate, we're a tech-enabled service and platform that is affordable, simple, and efficient. It's a one-stop shop for families who are planning or settling estates, supported by experts to guide you through the entire process from start to finish. I'll now hand it over to Sarah, my director, to tell you more.
Thanks, Matt, and thanks, Jeff. Great to be here with you guys today, and thank you for joining your first thing in the morning. Appreciate that. Just a little bit about me. My background is in the estate and trust field. I worked for many years at a trust company on both the estate settlement and the estate planning side of things. I have some professional designations that are important to have the necessary technical expertise, of course. But ultimately, my goal is always to make these topics more approachable and offer, practical guidance for folks. Now, today's learning sort of objectives is, of course, to understand some potential pitfalls in estate planning and how to avoid them and where to go for help. Now, I'm going to actually start off with a little bit of a poll out of curiosity here. Now you'll see it pop up for you as a question in a second. How many of you actually have a will and power of attorney document in place? So I'll give you a second here for folks to respond. And we'll see how this group kind of stacks up against the typical kind of average. Just give it another second here. All right, perfect. So you guys are actually exactly on par with what the average is. It's typically around 51% of folks that don't have the documents in place, and about 50 that do. Sometimes some studies are a little higher, a little lower, but generally speaking, a lot of folks I think know that they should have these in place, but actually they haven't necessarily got around to doing it. And myself and Jeff were just talking about how often that is because, it's an overwhelming process, and hopefully we can kind of help set you on the right path with dealing with your estate planning needs. Now, just a quick follow-up question. For those of you who do have an estate planning documents in place, how many of you actually feel that those documents are up to date? So I'm going to launch that question as well. And up to date meaning you've actually, they're recently done within the last 3 or so years, and you've contemplated kind of changes in your life circumstances. And that's all kind of factored into your plan. I'll give you a second here for those of you to answer. Okay, wonderful. So share those results. So over half of you don't necessarily feel your plan's up to date, or you're not really sure if it is or if it isn't. That actually, again, is pretty much on par with the way we see in general the population kind of stack up. Only about 35% of people who have wills in place actually feel that their plan is up to date. So we're going to actually dive right into some case studies. I'm going to tell you a little bit about specific situations where there was planning done. However, things didn't go as was intended. So this first case is about Bob and Sally. Now, Bob and Sally have charitable giving intentions. They have a particular charity that's near and dear to their heart. And so as a result, they've decided to leave a gift in their will of $300,000. The rest of their estate is going to go to their 2 children equally. Now, Bob and Sally, unfortunately, as they aged, developed advanced stage diseases and lived comfortably, but eventually passed away. And at that time, their estate value was actually significantly reduced by the cost of their care needs in that time period. You guys are probably aware that, particularly when you need a lot of support, it can be quite expensive to have your personal care needs taken care of. So when they originally did their planning, their estate value was estimated to be about $1.5 million. And so that $300,000 gift to the charity represented about 20% of their estate. And their kids would receive 40% each, around 80% of the estate. At their passing, since they hadn't revisited their documents in some time, their net worth was actually reduced to $500,000. But that legacy or specific gift to the charity, since that amount was sort of set in stone, if you will, by being specific in their will, they still receive that. Because of the change in their asset values, now the charity actually received 60% of their estate, and their children only received 20% each. Okay, so the lesson here is that this wasn't in keeping with their intentions. And so you really do need to revisit your plan regularly to ensure that it remains consistent with your intentions, especially as your circumstances change, including your asset values may fluctuate, right? Now, once you have actually lost capacity, you can't update your documents anymore. So there could have been some thinking around what would happen if this was something that number didn't make sense in future. They could have actually reduced the gift amount. They could have incorporated the charity as a residual beneficiary, which means they would receive a percentage of the estate, which would make sure that the overall proportion would be as they intend. Or they could have done some combination of that. But all of that to say, a discussion around that would have been valuable to them. So our next case study is about May. Now, May has 4 children, and May appoints her eldest, Juliana, as her executor and POA. May also develops dementia, and at 75, from 75 to 85, her daughter Juliana is actually acting as her power of attorney until she passes away at 85. So Juliana spends hundreds of hours during that time period ensuring that all of her mom's needs are taken care of. She really is a dutiful daughter, and she wants to make sure that her mom is well taken care of and all her needs are met. But Juliana does not keep careful records, mostly because she doesn't know that she needs to. Unfortunately, after May passes away, Juliana's siblings see less money than they expect in the estate. Now, remember, they're not really fully aware of the assets because they weren't involved in the power of attorney sort of day-to-day activities. So even though Juliana had actually acted prudently in this case, her siblings, she couldn't actually back that up with evidence. And by evidence, I mean transaction reports, accounting. And so her siblings actually took her to court because they wanted to know what had actually transpired with transactions. And that ended up costing thousands in legal fees, of course, significantly delaying the estate settlement. And needless to say, fractured family relationships that, you know, are ongoing through generations. And I think, you know, the important thing to keep in mind is that a lot of estate conflicts actually happen when siblings perceive that they're not being treated equally. And whether or not it's a perception or reality sometimes doesn't matter. Unfortunately, it's you know, intense feelings rise to the surface after a parent has passed. The other thing is that if you're acting in a fiduciary role, so as a power of attorney or as an executor, you're accountable to those who have an interest in the estate or in the power of attorney assets. And so you actually must be able to account for your actions in perpetuity. So you always must have records that back up your activities, right? In this case, May certainly could have, and her family could have benefited from considering a professional power of attorney for property and executor, which would have obviously enabled careful record keeping, but also, you know, prevented that family conflict. And I just want to remind everyone too, as Jeff mentioned, you can feel free to add your questions if you have any into the Q&A. At the end of the presentation, we will allow time to address those questions. Our next case study is about Don and Mary, and I call this one a careful plan unraveled. This is another thing that we actually see, unfortunately, happen commonly, where things don't go as something someone has done actually unravels things in a plan. So in this case, Don and Mary have 2 daughters, Sandy and Leah has a disability. They carefully consider Leah's circumstances in their estate plan, as they should, because there are special considerations there and things you may want to implement to account for that. Now, when Don passes away, Mary receives advice, which I put in quotations because it's important to understand that the advice wasn't from someone who necessarily is qualified to give advice. But her neighbor nevertheless gave this advice to make her kids the beneficiary of her life insurance policy. This is commonly done because we all have heard that, you know, probate fees, probate's expensive, it's a painful process, and naming direct beneficiaries is a way to avoid that asset being part of probate and the probate process. However, that could be good advice in some circumstances. In this case, she didn't check in with anyone about it. She didn't talk to her financial advisor. She didn't talk to anyone she regularly would talk to about these things, and she just went ahead and did it. Now, as a result, when she did that, she actually inadvertently revoked the initial planning that was done that carefully accounted for Leah's situation. And as a result, so the original plan had included a specific trust in the estate for Leah, where it would continue to protect her access to government benefits and that she relies upon, and also provides for some tax efficiency into the future. Now, on top of that, Sandy is acting as the executor. She's also needing to figure out what actually has to happen with Leah's care and her needs, right? Like how is she being supported now that both of her parents have passed away in this scenario? So I think the lessons here is, it's important to check in with professionals, and not to get too technical, but it's in this scenario, the probate savings can also be factored in to the strategies that they had implemented. So that actually could have already been accounted for. And if she had just revisited with the folks she should have revisited with, she could have avoided this unintentional outcome and this heavy burden for Sandy in trying to navigate all of this, right? They should have had holistic estate planning check-ins, and they could have, again, potentially considered a professional to be involved to alleviate that burden from Sandy. Now, our next case study is about John. This one is I almost want to call this the unobvious conflict of interest, because I think a lot of people don't realize that you can be actually placing your family members in a position of conflict when you're expecting them to fulfill certain roles. So in this case, John actually created a spousal trust in his will to benefit his current wife. So John had been previously married. He had a child from his previous marriage, Henry, but he also has a current spouse. And often spousal trusts are created to help to provide for a spouse while providing for, potentially the next generation, your children. Particularly in blended family situations, it's common to think of this. And in this case, he wanted to provide for Megan during her lifetime, but also have the balance pass over to Henry upon her death. Now, the terms of this trust included broad discretionary power, which basically means that the trustee could take from the capital of the trust for Megan's benefit and needs during her lifetime. So she would get the income from the trust, and she would also be able to take some of the capital from the trust. However, he makes Henry the executor and the trustee of his will. Some of you may be starting to see where I'm going with this one, but essentially what happens is Henry is in a clear position of conflict because he's the trustee of the trust and needs to make decisions in terms of Megan's interest in the trust, but he's also the eventual beneficiary of the balance of the trust. Those are kind of competing, not kind of competing, they're truly competing if you think about it, right? So Henry, as a beneficiary, wants to preserve and protect the capital of the trust because he's going to receive it ultimately, right? Henry, the trustee, is supposed to be impartial and treat Megan's needs and his eventual receiving the trust equally. That's actually really hard to do, even if you have the best of intentions. So in this case, Henry doesn't prioritize income earning investments, and he interprets his powers very narrowly, which means Megan has to make these detailed requests to Henry whenever she requires funds. He seldomly approves of these requests, and this is not really in keeping with John's intentions. So I think the lesson here is, ultimately, you the selection of your executor and trustee, it really is important to think about the ability of that party to actually act truly impartially, right? And that choice is really going to dictate how your intentions are carried out and whether they're successfully carried out and how smoothly things go, right? So again, you know, John's family could have benefited from a professional, considering a professional, or at the very least, like someone who truly is a neutral party in this scenario, okay? Our next case study, an unintended exclusion. So Bill is a proud grandfather. He's got 6 grandkids from 3 sons. His will includes what we refer to as a per stirpes distribution. Per stirpes is Latin term we still use in this field, in this specific context anyway. I'm sure most of you are not speaking Latin most of the time, but it's a term that basically means by bloodline. So it's the most common way that folks will distribute an inheritance, particularly to their children. It means that if a children were to predecease you, they pass away before you, then their children, if they have any, will stand in their place to receive their inheritance. And in this case, Jack actually does end up passing away prior to Bill. And so the intention is that Jack's children are going to receive Jack's share. Okay. What ends up happening though in this case is that when Bill's lawyer prepared the will, he actually used an outdated out of wedlock clause. We don't really use that term out of wedlock anymore. It's not really in keeping with kind of modern families. There's a significant amount of kids out there who are born without having their parents married, certainly in 2023. And but this clause was originally designed to protect the executor and the estate from, sort of people coming crawling out of the woodwork and saying, I'm a beneficiary, right? Now there's more modern and updated terminology that actually accounts for this protection without having what happened here, which was that Bill had never mentioned to his lawyer that Jack was actually never legally married to Liam and Charlotte's mom, his children's mom. So technically his 2 children were born out of wedlock, even though they're absolutely his children, and both Jack and his father would have wanted them to receive a share of the estate. But unfortunately, because of this outdated clause, these 2 grandchildren were excluded, and everything was split between Bill's surviving 2 children instead. Not at all the intention. Some people ask when I tell this, like, oh, well, couldn't they just like correct that as a family? Yes, they could decide to correct that. However, if you can imagine that conversation going on and how difficult that might be to try to say, okay, well, we should maybe give this, and then you're factoring in, everybody's in a different position potentially financially. There's all sorts of reasons why that's difficult to do, right? And they're not legally obligated to give anything to the grandchildren. So I think it's important to understand that when you're doing estate planning, it really does require a complete discovery of all the relevant circumstances, and that the content of a will should really be personalized for those circumstances. Now, of course, Bill could have benefited from a proper discovery with the lawyer, and the lawyer could have avoided using outdated clauses that are not thinking of the makeup of modern families. So our next case study, which I do believe resonates with a lot of folks, is about the beloved family cottage. Now, in this case, Rashad and Kesha, they have 2 kids and 4 grandchildren, and they have had this cottage for many years. And when their kids were young, they spent a lot of time there, right? So it's automatically has kind of a heightened sentimental value. They really do want their family to continue enjoying the cottage even after they've passed away. And so they leave their property and the rest of their estate equally to their 2 children. Now, that does sound wonderful, and I appreciate that in a lot of cases, this is the desired kind of goal for folks. However, there's practical and logistical issues with actually doing this, right? So when Rashad and Kesha pass away, first of all, there's a significant capital gain on that cottage property because it wasn't their principal residence. And they had not really thought of where the funds for that were going to come from, looking at their other assets and thinking about the fact that they're not going to sell the property, so they're not going to raise cash that way, right? There's also no plan for how the sisters are going to actually co-own the property, right? And if you have siblings like myself, you can probably start to guess at how things can get a little bit tricky, right? Who is actually, I have 2 siblings, and I know in my family, it's typically one person that ends up dealing with the brunt of the work. And I think that's quite common. So how will that be divided, right? Who's going to be responsible for actually paying the bills? Who's going to make sure, you know, it gets opened, it gets closed, the property taxes are paid, like all of those things that need to actually happen? Who's going to be responsible for that? And that's not necessarily something that you completely set out in your plan, but you need to think about how are your kids going to do that? And in this case, the other thing that tends to generate a lot of arguments, particularly where there's like, we're talking about large families, is like who gets the property when, right? Who gets to go there on the long weekends? That's a big issue as well. So as a result, the cottage property, unfortunately, quickly actually becomes a burden to Janelle and Jennifer, right? They also are both busy lives. They may have differing abilities to actually get to the cottage, you know, depending on where they live, and enjoy it. So it becomes a financial and emotional burden, actually. It creates strain between them. Now, I think, you know, it's a big one is failing to account for estate expenses, particularly tax liabilities. That's something that is very important, especially when you're thinking about giving assets like in kind, when you want to just give that asset outright to someone rather than sell it. And we need to think through the practical and logistical implications of that distribution plan, right? They could have considered a trust, and they could have set aside some funds in the trust that were clearly going to be used for the purpose of maintaining the cottage. They could have also required that their daughters have a co-ownership agreement to like set out, you know, how the property would be managed. And there's a number of other things they could have considered as well. They could have considered, you know, having a discussion around, do the kids even want the property, right? Like, I appreciate that there's sentimental value there, but, you know, practically speaking, is this something that they want? Or does one person want it and the other one doesn't? Like, there's lots of different things you could look at and think about in order to plan for success with a recreational property. Okay, the next case study is the unequalized inheritance. So this is about Nicholas and Pedro. Now, Nicholas and Pedro, they have 2 adult children, and they have given or plan to give significant gifts to them when they sort of reach or have significant life events occur. And this is also common. Lots of parents want to give their child a financial gift when they get married or buy their first house or have their first child. It's very, very common. Now, in their case, they want for these gifts to be taken into consideration in their ultimate estate distribution down the road. So in other words, they want for the gifts during lifetime and gifts from their estate to kind of all be brought into one pot for consideration, right? This is what we refer to as a hodgepodge clause in a will. And it means that they're going to equalize the gifts that they made during their lifetime in the estate distribution, right? So in this case, by the time that Nicholas and Pedro actually pass away, they have provided 2 significant gifts to Louis when he purchased his first home and also when he got married. Isabella just so happened to have never done either of those things and therefore did not receive any significant gifts from her parents. Now, what ended up happening was after Nicholas and Pedro passed away, Louis actually somehow managed to forget that these gifts had ever been given to him. So there's no proof that could actually be provided for the fact that he had made these, for the fact that they had actually made these gifts. And as a result, Isabella and Louis received their share of the estate without any equalization and basically never spoke to each other again, right? Because now we have a actual real slight, not just a perceived one, and someone has truly been treated unequally. So I think that's important to kind of to understand. And as a lesson, I think, you know, estate planning really doesn't stop at just signing your will, right? You have to continue to document anything else that's kind of, you know, supplementary information to make sure that your intentions are, you know, understood and can be fulfilled. And unfortunately, you can't rely on beneficiaries to be honest and forthcoming. You need to align legal obligations with moral ones instead of expecting people to simply do the right thing. And I know that sounds kind of cynical, but I've seen enough to say that my recommendation is to always make sure that what you intend to have happen is well documented in a proper plan. And which they could have done. They could have had these documents, you know, at the ready for their executor to deal with. So I think, you know, in summary, why planning matters, you know, certainly you want to protect your loved ones, right? And it's important that you think about maintaining your family harmony, lessening the burden and strain on them. Are they going to actually like get along after everything is said and done? And if so, you know, like, how can you effectively do that in your plan, right? Like, how do you actually accomplish that? How do you set them up for success, basically, right? You want to minimize expenses, of course, wherever possible. You don't want to be paying more fees than you need to be, either in taxes, in you know, estate expenses, or, you know, professional fees. You want to carefully think that through and plan ahead for it. You also want to safeguard your family's financial future, right? By thinking about how do you effectively, you know, maintain your goals even after you've passed away, or your goals for your family. You absolutely need to select the right representatives. You need the right folks to be in the executor, power of attorney roles, guardians for minors. If you do have trusts, you really want to think through those roles carefully and have the right people doing those jobs. We didn't talk about this, but definitely incapacity planning is a big piece as well. You want to make sure that your intentions are captured there, and that will be successful in carrying that out. And that's not always straightforward. That can get complicated as well. And then you want to make sure that there's customization in the plan for your specific circumstances and needs. I'm gonna actually do one last poll question, so bear with me a moment while I get that up. So I think, you know, you should see it on your screen. At this point, I know we talked about some things. Do you think, you know, it might be worthwhile to review your estate plan? And I'll give you guys a second here to answer that. Okay, I think everyone had a chance to answer it. And I do, this is also, you know, pretty consistent with what we tend to see, is that like about 86% of you here do feel that it's worth reviewing your estate plan. And, you know, the end result might be that everything is perfectly fine, right? And whatever you have in place works. However, if we don't review it regularly, we don't know that. And certainly there's always, new things that arise that you need to think about. Sorry, I meant to show, I was going the wrong way here. And so I just want to mention, in summary, all these things that are changing do have an impact on how we do estate planning, what strategies we consider. Families are becoming more and more complex. What is important to the next generation is not the same things that are important to the previous one. That tends to be the case, and then we have emerging technologies that make things potentially easier for folks, right? And then of course we always have ever-changing legislation, right? Whether it's tax legislation or legal requirements, all of those need to always be thought about. I'm going to spend just a couple of minutes explaining a little bit about how ClearEstate does estate planning, and then we'll dive in to see if there is any questions. But essentially, the process of estate planning that we do at ClearEstate, it's pretty similar probably to the process of financial planning. You're going to have a period of kind of discovery where you're meeting a estate professional, we're intaking your personal and asset information. And then we're going through your goals and your concerns, and then offering some guidance and coaching around what are your key considerations, what decisions do you have to make, kind of the options that you have, and then actually creating a personalized estate plan that and implementing the documents themselves that are needed to materialize this plan. So your will, power of attorney documents, and then of course, store those documents securely, making it more easy for your loved ones when that time comes to actually have access to the information they need, and kind of give them a bit of a head start and set them out on the right path in dealing with the very overwhelming process of estate settlement. And I think we also, this may have been mentioned to you previously, we do offer professional services where we can actually, through our fiduciary partner, we can actually take over the executor role and professionally manage your estate settlement, which lots of folks do think about, because it's a way to alleviate that burden from your family, make sure everything is done properly, and that it has the expertise and continuity of professionals who are a neutral expert third party. So that's all something that we could potentially help you guys with. We do have some testimonials online available, so don't take my word for it, but feel free to check out that sort of social proof of what we're doing with clients. And of course, please, feel free to discuss your estate planning needs with Jeff. We do offer free consultations, but absolutely talk to Jeff, and we're happy to help support your needs. So from there, I don't know, Matt, if you want to see if there's any questions.
No, excuse me, I don't see any questions as of right now.
Well, I'm gonna
I just
pipe in
want
here with some questions that I might have here for
yeah,
you.
perfect.
Sarah, so I want to thank you first off for that great presentation. I'm really glad you were able to show us those real life examples of how estates go wrong. And as a matter of fact, in one of the last case studies about the cottage, I actually know someone who went through that exact situation, and they ended up having to sell the cabin due to the conflicts in managing the property with the siblings. So it was a little bit. Aside from, before we get into other questions, Matt, that you might just see in the chat box or in the Q&A, I want to just ask you a couple questions here, if I can. I have a few. Like in the first case study, about the very generous gift to charity, that one. I understand you'd recommend reviewing and adjusting the will every few years and even annually, and which is great because that's an opportunity that exists with ClearEstates. But as we go into long-term care, it seems to get harder to focus or remember even to make those adjustments that you're talking about. How do you recommend, like in that example where you left $300,000 to a charity when you set up the will? Now all of a sudden you've gone from a $1.5 million estate to a $500,000 estate or whatever. Well, leaving $300,000 is quite substantial and leaving very little for the kids. So, would you recommend a percentage for the charity gifting versus a dollar amount, or would you suggest something else?
Yeah, it's a great question. And I'll preface this by saying, there's no one size fits all, but there's pros and cons, right? So the advantage of doing adding the charitable giving as a residual beneficiary is that you will for sure always be able to maintain the intended proportions, right? The potential disadvantage that some people don't like is that if a charity is a residual beneficiary, that means they're entitled to a complete accounting of the estate, and your executor is sort of accountable to the charity to give them, details about all your assets, because that's what residual beneficiaries are entitled to, right? Because if you say you get 20% of the estate, how do they know what 20% means unless you provide them with an accounting, right? Some people don't like that for privacy reasons, right? But at the end of the day, I do generally say consider a residual gift. It's more, I'll say, safe, because if you give a legacy gift, it doesn't take into consideration what the rest of the balance of your estate is. That legacy gift goes first. So you've locked it in, and it's difficult. While it makes it simpler, because then all you report to the charity is, here's your $10,000 gift, and that's all they get to know. Some people even do a combination. So some people might do a gift they want to set aside for sure they want the charity to get, and that they specify that amount and they're comfortable with that and they're very confident, okay, I'm going to have at least this, I'm going to be okay with the charity getting that. And then they can potentially think about, I've even had clients who said, like, if my estate is greater than X, then the charity can receive, X amount. So there's actually lots of different ways you can deal with it. And like I said, there's no one size fits all, but the challenge with setting a gift amount in stone is that if you become incapacitated, you can't make an update to that, right? Or like you said, if there's challenges practically with you getting your estate planning redone, it's more difficult.
The nice thing I like about the clear estates is that you can adjust it as you go along year after year. And because you're constantly having total control of it, as opposed to having to go and see a lawyer, which, or a notary, which people tend to want to do. And then they end up not reviewing it for like 5, 10, 15, 20 years,
Yeah.
So with the clear estates, at least you have that opportunity. So I like that. There was another question, that I'm thinking about. So in a situation where there's like 3 adult children and they've asked to have their names added to the house as co-owners, to avoid probate. That's, one of the things. When planning the estate, is that a good idea, or, how does that, play out where a problem could exist?
Yeah, that is a great question. And I generally, I would say almost on every webinar I give, I get some version of, should I joint, my assets with my ultimate beneficiaries? So again, pros and cons, but I would say the biggest challenge with thinking about jointing assets is you might be creating some probate savings, but you might also be creating some tax implications for you. So for example, if you're adding, someone who's not your spouse as another owner on your property, is that considered a disposition of some portion of the property? And if that's not your principal residence, that may have a tax implication for you right now that you don't want to have happen. And then the other issue, which I think is actually a bigger issue, is that you're creating some risk also, right? If you add somebody else to the title of your property, you're potentially giving up some form of control, because that person ultimately they would have to participate in whatever decisions you're making about the property. And there's exposure to if they have potential creditors, you know, is that if maybe they have a marital breakdown situation, is that asset now part of their net family property? And so there's a lot of risks associated with this. And then there's also kind of back to, I believe what I was talking about earlier, which is that, you know, if the intention is for them to also then do something else with that property, like share it with someone else or provide some cash consideration to someone else, will they actually do that? Right? Which is something that's commonly done is people will add somebody to title, they'll add one child to title, and then they'll be like, after I die, you won't have to do probate, but then split it with your siblings. We see that a lot. And unfortunately, how things actually transpire is not how you think they're going to transpire.
You know, that's aside from the cost of probably having to go and get them on title and organizing that, which sometimes doesn't end up saving the probate on that. So it ends up costing more probably in the end, and that's where I would probably see a problem. Questions that keep coming up to me is it a good idea to have a lawyer or is it a bad idea as the role of the executor?
Yeah, great question. So lawyers, not all of them, some of them will agree to act in the role as executor. When they do that, the advantages are that, you know, you have a professional. Typically that's good because estate settlements are not easy to navigate. However, lawyers can basically, the way it works is they're appointed personally. So their name is in your will, right? And so if something happens to that lawyer, you're still kind of at the same, it's the same as if, you know, you appointed your neighbor and they're not around or they don't want to do it anymore. Like there's still a bit of question mark as to whether or not they'll actually be able to do it. And the other thing is, a lot of lawyers, when they do this type of appointment, they actually don't necessarily fully discuss the compensation that they're going to be receiving. And typically what happens is every province has a guideline a court guideline for what executors should be entitled to in terms of compensation. That's whether it's a professional or, you know, a lay person, an individual. And when you can set out compensation in your will, or you can leave it and, you know, let the executor, you know, confirm with the court. But generally speaking, most jurisdictions, 5% of the value of the estate assets is what an executor, it was considered reasonable to take in terms of compensation. So what usually ends up happening is when you appoint a lawyer, they will take the 5% compensation, and then they will also charge for kind of the legal work of preparing the probate application and anything that, you know, they can get their law firm to kind of do is also charged on top of that. And then at the end of the day, in a lot of cases, approximately 10% is actually lost in fees to professionals when we're dealing with estate settlements, which is a significant number. So
big difference between, you know, 5% of $1 million estate and 5% of a $10 million estate, obviously.
yes. Yes, absolutely. And there's no cap, right? It's for lawyers to seek that type of compensation. Clear Estate charges 1% when we are involved as with our fiduciary partner to do to do that work.
Okay. Matt, if you've got questions that are coming up, just let me know because I've got so many questions myself. But another question I've got for you is the pros and cons of appointing a family member to as an executor. I think you went through one of the case studies and you mentioned something like that, but can you just kind of elaborate on the pros and cons of having a family member?
Absolutely. I would say, you know, one of the obvious pros is like they personally know you, right? Like, and if it's somebody you're considering for this role, I would imagine that you trust them and, you know, you're close to them. That's definitely a pro. I think also I would think that they have like sense of duty towards you if you're, if it's a close family member or friend, right? So you would trust that they're going to do their best to actually carry out this role. In some cases, though, that's actually turns out to not be a great thing, because folks who actually feel obligated to do it, but may not actually be up to it, will still try to do it, right? So that can actually end up being a con. I would say the disadvantages are, like I was talking about in that one case study, is that, in almost every case, if it's a family member, they're almost always also a beneficiary, right? And whether it's real or perceived, there's always this notion that that the executor has some sort of additional advantage of just being in that role, right? Even though it's not like they get to say like, oh, I get to give, it's not like they're deciding how the estate is distributed. That's not up to them, but it still almost feels like that to other family members. And that actually creates quite a bit of conflict and strain in relationships, right? And causes people to start asking, doubting things and asking all kinds of questions that if a professional was involved, alternatively, they would automatically know that party is neutral, right? And they wouldn't have that added kind of emotional aspect of things. Now, one thing that people can actually consider that they may not know is, and Clear Estate is able to do this as well, is you could actually appoint both. You could appoint a professional and a family member to act together, so that you actually are covered kind of from both angles if that works for you and your family, right? So some people are like, no, I don't want the burden on my family at all. Some people are like, I want the professional, but I also want my family to be involved in decision-making. And then that's where, considering both together is a good solution.
Clear Estates does something like that, don't they? They have the
Correct.
options of
Yeah.
Providing both assistance to an executor, someone who's named as an executor, or be the executor themselves, right?
Yes, and we can also act as a co-executor with a family member. So we
That's
would
good.
do all the heavy lifting, but they would actually be involved in the decision making.
That's perfect. Now, one of the, I know one of the biggest mistakes in estate planning is not having a will. I clearly that's it. And there's no real, most people think about having their wills done as they get on later on in life, as they're retired, and they start thinking about it. But I know it's really meant for anybody and everybody, any adult that should have wills in place. But what do you find is the most common mistake, aside from not having a will at all, in estate planning?
Oh, that's a great question. I would actually say that sometimes the only thing worse than not having a will is having like a bad one, right? So
Right.
if you have a will and it actually is not part of a comprehensive estate plan, you could be making things actually worse than what could potentially happen if you didn't have a will at all, right? So I think that that's the main thing. Also, very commonly, folks do their will and then don't update it for so many years, and meanwhile all kinds of things have changed in their life circumstances. That I would say that is like super common. They've named a beneficiary that was like 3 marriages ago, or like it's very common that people don't update their wills for many years, or they may think about the will but not like those other pieces, like an individual, like an actual life insurance policy and the beneficiary designation on that specific life insurance policy. That's where I think things can commonly go awry.
Yeah, it's one of the reasons why I got involved with Clear Estates, your company, organization, kind of partnering with you, is because I found that the biggest problem was that I find with my clients is that they've set the will, but they forgot it.
Yeah.
And that old saying of set it and forget it, that goes all the time. And so 20 years later, they have never updated their will. Things have changed dramatically. There's so many more additions to the family. There's so many different issues of that they have to take care of. And the thing I liked about the joining up with Clear Estates is that you can adjust it on an annual basis or throughout the year. And it's pretty straightforward because you've got the clear estate vaults, of course, that keeps all your documents organized and everything. But aside from that, that you're dealing with a professional on an ongoing basis annually, so that as things change, if you've got questions that come up, that they can address it with you. So I really like that.
Yeah, absolutely. And I'll also add that I know that estate planning, it's not like fun, right? Like it's not actually like a fun thing, exciting thing to do to, go through all of this. It's actually kind of painful, especially if you're doing it right, which I sometimes refer to as obnoxiously thorough. But it is something that's really important, right? And I think what happens a lot of times is people know that they want to do it, they know that they need to do it, but they don't really have the right tools to do it simply and efficiently. And as a result, they kind of get overwhelmed and stalled in the process. And I do think that that's what we really try to help people with, is kind of, nudge you to complete the process and go through the steps that are needed. And then, at the end of the day, you have that peace of mind of knowing that, your loved ones are set up for success. And, and yeah, as you said, like you can revisit, but even the process of revisiting, it's not as painful because, you have everything tracked clearly, and it could be even just a very quick review of like, okay, does everything still make sense? Okay, here's my distribution plan. Yep, that all makes good sense. And moving on, right? You might not actually need to make changes, but just a quick review is good to do.
Absolutely. Well, I know we're coming close to the end of our session today, but so Matt, is there any questions that you've got typed in there anywhere? If not, Karen, you've got something?
Yeah, actually, I did have a question for Sarah. There was one situation where you talked about the unequalized distribution of assets, where the couple gave their son some money while they're still alive for his house, whereas the daughter Isabel had not owned a house at that time, so she did not receive any funds. And then when they passed away, there was no documentation to back up the fact that they had given the son some money. And so in terms of the actual documentation itself, would you suggest a notarized letter that you tuck in with the will, or is it just a letter you can draft getting the children to sign it? Like what level of documentation would be required for that?
Yeah, that's a great question. I don't think, notarization, it's always great, but it's not a legal requirement, but I would say a record of the actual transaction occurring, right? So like that statement that shows that it went from this bank account to this bank account, or a copy of the check, and then a letter, preferably even signed by the child who received the gift. But at the very least signed and dated with, the date of the transaction by the testator, the client, for sure.
Okay, yeah, I was just wondering because in that example, you're saying there is no documentation, but in my mind, I thought, well, wouldn't there have been something that maybe the banks could have helped Isabel with potentially?
Yeah, absolutely. But that's not always easy to come by, right?
True. Okay.
Depending on how long ago the transaction occurred. If you don't know the date, then you would actually have to go to your bank and you would have to like order statements from the last, like it's
10, 20 years.
Yeah. And then they charge you for each one. So,
Right.
it's I think the goal is to make it clear and easy. And the other thing too is if your executor doesn't even know that those gifts took place, like how would they even know to go to the bank and ask for proof, right? So
exactly. Yeah. Okay.
all of these things are important for sure. Was there any other questions?
Matt, nothing? Well, if there's
Not that I can see.
If there isn't any further questions or comments, Matt, I want to thank you. Sarah, I want to thank you also for the States Gone Wrong presentation today, and thank all of you who attended today and for taking the time for joining us. Now, for all those who did attend, if you'd like to receive something, a free startup kit that we send out here from Greenfeld Financial for organizing your wills and get drafted, all you have to do is just send me an email or just phone our office and we'll be happy to send you a copy. And if you've got any other questions that you haven't typed in or you haven't added in here, but you'd like more information on how Clear Estates can help you, or if you'd like to set up a free consultation to ask some more questions directly with Matt or Sarah from this meeting to discuss your personal estate needs, then our contact information is on the screen, as you can see here. You can either go to the email, go to theclearestate.com/Greenfeld and set up a time. Also, Karen's posted that in the chat box, I believe, Karen. And if there is no other questions, we've come kind of to the end. We've got about 30 seconds left. So again, I thank you all for attending, and Sarah and Matt, thank you for putting that presentation on.
Pleasure.
Thanks, everybody.
Guys,
And
bye-bye.
enjoy the rest of the day.